Hey guys, today we are diving into an important topic for employers and foreign workers in Singapore, the work permit issued by the Ministry of Manpower. Now, we'll be covering eligibility criteria, countries of origin, conditions of employment, and the relevant laws. First up, let's talk about the eligibility criteria. Now, in Singapore, work permits are typically issued to unskilled or semi-skilled migrant workers in sectors such as construction, manufacturing, marine shipyard, process, and even services. The work permit duration is generally 2 years, subject to the validity of the worker's passport, the security bond, and the worker's employment period, whichever is shorter. So to be eligible, the worker must meet certain requirements such as age, qualifications, skill levels, which vary by sector. The number of work permit holders that a company can hire is limited by a quota or a dependency ratio ceiling and is subject to a levy. That means the employer has to pay a levy to the government for each foreign worker work permit that it employs. Let's talk about the eligibility criteria. Age. Applications for work permit are for persons between the age of 18 years old up to 50 years old. There is an exception for Malaysians, which is 58 years of age. The qualifications vary sector by sector, often requiring certain relevant skills or even certifications. The Ministry of Manpower specifies that certain countries from which employers can hire workers. These source countries are categorized based on the sectors that they are allowed to work in. The construction and marine sectors are allowed to employ nationals from Malaysia, Bangladesh, India, Myanmar, Thailand, China, Taiwan. On the other hand, employers in the manufacturing industry are allowed to employ nationals from Malaysia, China, India, Bangladesh, Myanmar, Thailand, and Sri Lanka. Those in the services sectors can employ nationals from Malaysia, Hong Kong, Macau, South Korea, and Taiwan. It's important to note that different sectors have different source countries, so always check the MOM guidelines. Let's move on to the conditions of employment. Employers must ensure that work permit holders comply with the conditions set out by the Ministry of Manpower, which include proper accommodation, timely payment of salary, and adherence to work hours. Additionally, workers cannot engage in any business or take on unauthorized work. In other words, those part-time or freelance work. Employers are also responsible for sending back their workers once their work permits expire or are cancelled. Finally, let's discuss the relevant laws. The primary legislation governing work permits is the Employment of Foreign Manpower Act. The Act outlines the obligations of employers and employees and the penalties for non-compliance. Under the Employment of Foreign Manpower Act, violations such as illegal employment, non-payment of salaries, and failure to provide proper accommodation can lead to hefty fines and even imprisonment. Now let's move on to a very interesting regulation for work permit holders. They cannot marry a Singapore citizen or permanent resident in or outside Singapore without the approval of the Ministry of Manpower. Work permit holders also cannot get pregnant or deliver a child in Singapore during the validity of their work permit, unless they are already married to a Singapore citizen or permanent resident with the approval of the Ministry of Manpower. These two regulations apply even after the work permits have expired or have been cancelled or revoked. That's all for today, folks. Don't forget to click like and subscribe.